Just because you use a gig app to find work, it doesn't mean labor laws don't apply to you. The gig app industry is growing, and my office is getting more and more questions about it. Because it's a newer industry, there's some confusion involving labor and wage laws. We're here to help clear up some misconceptions.
Denver Labor, a division of the Auditor's Office, promotes lawful employment and wage compliance. We investigate any potential violations. Generally, gig app companies work with businesses to provide short-term work opportunities, which people can apply to using a smartphone app.
There are all kinds of gig apps you may have heard of before. There are ride-sharing apps like Uber and Lyft, delivery businesses like DoorDash or Uber Eats, odd job apps like TaskRabbit and Thumbtack, or general work like Fiverr and Upwork.
Today, we'll focus on gig staffing companies. Like traditional staffing agencies, these companies work with their clients to fill open jobs. But unlike many staffing agencies, gig staffing firms often violate their workers' basic rights. Some gig app companies, or even the hiring business, might not be based in Denver or in Colorado. Although that might make it hard to resolve labor or wage disputes, it doesn't matter where the company or business is located.
If you use a gig staffing app to perform work in the city and county of Denver, then Denver's wage and labor laws apply to you. Workers should earn at least the minimum wage, which in 2025 is $18.81 an hour. If you perform tipped work through the gig app, it's illegal for the gig app or the client to keep those tips from you.
If you use a gig app to get work, you should find out if you are an employee or an independent contractor. Gig app companies often misclassify their workers as independent contractors. This practice is enormously harmful for workers. Independent contractors are often denied common workplace rights, such as minimum wage, overtime, paid time off, paid sick leave, workers' compensation insurance, and other workplace rights and benefits.
This misclassification hurts everybody, including legitimate staffing agencies that follow the law, treat their workers fairly, and pay their taxes. They struggle to compete against gig companies that have an unfair advantage based on breaking the law.
We've seen gig app companies break the law, and we've seen others be proactive to do the right thing. In 2024, we determined that InstaWork misclassified nearly 3,000 people as independent contractors. The gig app broke Denver's minimum wage ordinance more than 1,000 times and failed to pay overtime more than 700 times.
In a different case, GigSmart contracted with companies to place workers. We found $22,000 in wage theft at those contracted companies. Although those companies could have been liable, GigSmart took responsibility and ensured that money was paid. More importantly, they proactively changed their business model throughout Colorado. People looking for work through GigSmart are now employees, not independent contractors.
You can rely on our office to work with the gig app companies and gig staffing companies to ensure compliance with wage and labor laws. This work is crucial to ensure that workers are treated fairly and every business gets to compete on a level playing field. We encourage anyone with questions about gig work to contact us. You can reach out anonymously and we never ask about your work status. Well, that's it for this episode of Ask the Auditor. If you have a question, submit it to auditor@denvergov.org, and maybe your question will be the next one we answer on the next episode of Ask the Auditor.